Hello from the Heartland. My name is Jenna, and this is Smarter News. News when it matters and why it matters. Our Smarter series features unique people who help us think and live smarter. Well, you've probably heard on the news that one of the biggest stories of 2021, and there are many big stories of 2021, is really about abortion law in America and some challenges to existing law. But one of the things that I've noticed as a journalist throughout my years in journalism and as part of Smarter News is that what we actually think about abortion law in America is not always accurate. And let me just add this. There's been plenty of experience that I've had working on in more traditional media where a comment has been made about stories having to do with abortion. And I'll give you this line, and it's difficult for me to say out loud, but I think it's important that you know this, and I'll be curious what our guest thinks about this. I often was told when I wanted to do a story about abortion or what was going on with legal challenges regarding it, that abortion doesn't rate. Abortion doesn't rate on the news. And therefore, we weren't going to spend any time on it. But you see, when that happens, then that means you outsource the definition of abortion law in America to pop culture and other things. And I think that sort of adds the confusion about, well, what is current law? What are these legal challenges to current abortion law? What are the stakes? And that's why I'm so excited about our guest that we have today. Professor Mary Ziegler is a professor. She's a legal historian. She's also an author. Her latest book, Abortion and the Law in America, A Legal History of Roe v. Wade, is a brand new book that's out as well. She's another one coming up. But here's what you should know about Professor Ziegler. She is the leading voice on abortion law in America. And I'm really grateful for you to spend a little time with us today, Professor Ziegler. Thank you so much.
Well, thanks for having me.
How did you get interested in abortion law and everything around it?
So I was actually a second-year law student at Harvard Law, and I was taking a legal history course. And a lot of legal history is sort of written around the idea of, if you want to change the world, or if you want to change the US, if your ambitions are a little bit more modest, like, can you use law to do it? Like, does that work or not? Or is it more sort of like a hollow hope? And so we read, what you'd expect. We'd read books about the civil rights movement. We would read books about the right to work movement. And so I kept wondering when we would read the Roe v. Wade book, because when I, before law school, when people talked about, does work in the courts backfire or not, often they were talking about Roe. And we got to the end of the semester, didn't read that kind of book. So I asked my professor, basically, what's up? Like, why didn't we read that book? And he said, well, there's not really a book like that's been written. And so I thought, wow, I was really curious and I wanted to know. And I think the more I worked on it, the more I realized that when you want to learn about abortion law or politics in the US, what you tend to find is people's opinions on whether abortion is good or bad. And that's important, but there was like very little information about how politics got this way, how law got this way, or even just what was going on. So I would say very basic things, right? Like the idea that the pro-life movement was not always affiliated with the GOP. Like, that's, if you study the history, that's really basic. And I would say things to people who were really informed, they would be really shocked. And I think the more I did it, the more I realized there's really a lack of information out there. And that's something that's value I can add as a professor and a scholar. And that's what got me interested.
That is so fascinating. I mean, that is fascinating to think. I would never imagine that a law course would include a deeper conversation on this particular topic. But there's a lot of things that surprised me about journalism school too. And when you live in the actual world, you're like, oh, that's actually missing from the conversation. And I noticed this. I noticed this for myself in my own reporting, when you kind of come into a story midstream and you don't have that foundation to understand, what happened at the beginning, then it just creates a muddled path. And so my goal today is sort of to be like a student in your class, Professor Ziegler.
Okay.
And ask some basic questions about existing law and the challenges that we're seeing in 2021 that are unique. And so maybe let's just start with a very basic question, which is, what is the current state of abortion law in America? What should every American know about it?
Yeah, I mean, one of the most basic things is that when we talk about what the Supreme Court's going to do, we usually ask, is the Supreme Court going to overrule Roe? And that's not really the right question to ask, although it's not completely wrong. So in 1992, the Supreme Court already overruled part of Roe. So there still is a right to choose abortion in American law. That right to choose abortion applies until viability, which is usually the point at which a baby or fetus can survive outside the womb. So that's usually, it kind of varies depending on the hospital, but anywhere from 21 weeks to 24 weeks. Prior to that, the right to choose abortion applies. Other than that, the Supreme Court got rid of everything that Roe v. Wade once stood for. So when Roe v. Wade was the law, states really couldn't regulate abortion much at all in the first trimester. That's not true anymore. Now states are allowed to regulate as long as the regulations aren't what the court calls unduly burdensome. So what we're really thinking about is whether we're going to move from the world we're in now, which is already not the world of Roe v. Wade. That's the reason why, for example, if you live in Alabama and you're listening to this, your laws on abortion are very different from the laws that you might have if you lived in Massachusetts. Planned Parenthood versus Casey and this undue burden test allows that to happen, right? It allows more flexibility within the state. So we're talking about whether we're going to move from that to the Supreme Court saying essentially the Constitution doesn't say anything about abortion, so states can do whatever they want. I think that's important because people often don't understand where we are, and therefore they don't understand where we could be going next.
Well, and I have to admit that I too thought, well, I abortion access in America is unconditional. I thought that at one point, that as a woman, that's something that every woman in America has access to. And it really was a light bulb moment to understand that, wait a minute, actually abortion access is limited by law already, depending on where I live. And let me just add this. You did something really important in what you just said. You mentioned baby and fetus, and there's so many different strong opinions about this issue. It's a highly personal issue. It's a highly political issue. I just want to recognize that. Sometimes on Smarter News, the term we've used is unborn. I know that some people will say fetus and some people will say baby, and it may be used interchangeably at times. And I just want to point out to our audience that if that happens, I'm not trying to make any sort of broader statement about it.
Yeah, and I try to use both for the same reason. Like I'll say pro-life or anti-abortion or fetus or baby or unborn child. Like I think most of the time, I think if you have to pick one, I would pick the terms people use to describe themselves just out of respect. So I think, pro-life and pro-choice are better just because that's how people see themselves. And it's good to respect and empathize with how people see themselves. But yeah, totally. It's fraught. How the terms you use are fraught. And that,
you just said it so eloquently. I think that's just the broader point I was trying to make, which is like, listen, we just want to have a broad conversation about this. And I think it's important to recognize the different opinions on it. So right now, Professor Ziegler, how would you describe abortion law? Is it just simply that, listen, the states are able at a certain point to restrict or limit or have some sort of impact on access to abortion? Is that just generally what's true in America right now?
Yeah, there are limits on what the states can do. So what a lot of the fights are about now is that it's most of the restrictions that the Supreme Court has upheld have been more limits on specific techniques, right? So like what doctors can actually do in the operating room if they're performing an abortion, or limits on funding, right? Some people may have heard of the Hyde Amendment. There's limits on if you're a patient on Medicaid, if you can get reimbursed for an abortion, both at the state and the federal level. And there have been restrictions on things like how long do you have to wait before you get an abortion? Do you have to sign a consent form? If you're a minor, do you have to talk to your parents, et cetera, et cetera? There haven't really been many laws or any laws that the Supreme Court has signed off on that are outright bans, right? So at 10 weeks, you can't have an abortion. At 15 weeks, you can't have an abortion. At 3 weeks, that sort of law has never been upheld. So there's a wide range of restrictions from state to state. Some states allow abortion quite late in pregnancy. New York amended its laws recently to do that. States like New York also often fund abortions, and allow people who aren't, licensed physicians, like physician's assistants, for example, or nurse practitioners, to perform an abortion. Then you go all the way to sort of the other end of the spectrum, where states restrict abortion as much as they're legally able to. And we see that reflected in the numbers of abortions, right? There's some states that have very, very few abortions already, and their abortion rates are very low. And we see other states that comprise, a pretty large percentage of the nation's total. So there's sort of, I would say, three categories of states. So you could live in a state that's sort of maximizing restrictions on abortion and already probably has a law in place that would ban abortion outright if Roe is gone. You could live in a very, very kind of blue state that's likely got some measures in place to ensure access to abortion, or you could live in a kind of purple state where your laws could be, like I live in Florida, that's pretty purple on abortion, where something in between is likely to be true, where you'll have some restrictions, but not other restrictions. And no sense that where your state's going to go if the Supreme Court does actually eliminate the idea of a right to abortion down the road.
So one of the things that you said is that if Roe is gone, but we also just learned that maybe Roe isn't necessarily the main driver behind current law. So can you talk to us a little bit about why, if Roe is gone, I don't even know if that's the right legal term to use. What would be the right legal term if Roe v. Wade is no longer a part of the law? And what are the stakes for that? How would that impact current law right now?
Well, so probably the most accurate way to put it would be if Roe and Casey are gone, because Casey sort of saved parts of Roe, but kind of rewrote Roe. So it's almost like if you imagine like you're doing a seance with your friends when you're in middle school and you've got like the Ouija board, it's like, Roe as channeled through Casey, right? So what would happen if Roe and Casey were gone would be that we would expect, and it's not exactly clear, right? Because some purple states are redder than others, right? But we would expect that, roughly at the moment, we are pretty confident that between, say, like 20 and 25 states would ban all or most abortions if the Supreme Court overruled Roe and Casey, and would do that pretty quickly. And then of the remaining, whatever, between 25, roughly say 20 to 25 states, there would probably be a range of outcomes, anywhere between states introducing some more restrictions, but not many, states just living with their status quo, or states actually expanding access. And I think the expanding access point is going to get to be pretty interesting too, because of course, before 1973, before Roe v. Wade came down, it was not easy, right? If women wanted to go have an abortion out of state, that was not a small thing, right? There were not that many people flying on airplanes. There weren't that many people driving, long distances. Like that would have been a much bigger deal than it is now. And also there's medication-based abortion now. If you live in a state where it's legal, there are companies that will, send you medication abortion on the internet, right? So there's going to be interesting questions too, I think, about what happens when states don't agree, right? So if you're a woman in Alabama and you drive to Massachusetts and get an abortion, and Alabama doesn't think that's legal and Massachusetts does, then who gets to decide, like whose rules apply, whose court's even going to hear it? And we don't really know the answer to that. So there are some things we can be pretty sure we know. There are a lot of other things we don't know, right? We don't know what some states are going to do. We don't know when states ban abortion. We don't know what they're going to mean by abortion. So there are some things we all agree are abortion, right? There's certain medications that are abortion. There's certain surgical procedures that are abortion. Then there are other things where there's disagreement, right? So for example, some people who are pro-life or anti-abortion think that emergency contraception is actually abortion because they believe that it blocks the implantation of a fertilized egg. The American College of Obstetricians and Gynecologists, along with most pro-choice people, think it's not an abortion because they think it delays ovulation. So they think there's no fertilized egg in the picture at that time. So things like that, right? We don't know when states say they're banning abortion, what they're intending to cover. The same thing goes for people who are seeking fertility treatment. There's some steps in vitro fertilization that some people view as abortion. So there's a question of whether, if you have an abortion ban, is that going to be swept in or not, right? So we don't know those kinds of details. And then we don't know when bans go into place, how easily they're going to be enforced, or how the courts are going to sort out these conflicts when states don't agree, because we can be pretty sure they won't agree.
That's so interesting. And it brings up so many different points, including how medical advancement technology has impacted this conversation beyond when some of the initial laws were passed, as you mentioned, in the 1970s and the 1990s. Right now, what is the right now in America? The current law allows a right to an abortion at a certain point in pregnancy, depending on where you live. Would that be an accurate way to say
Yeah,
it?
I mean,
What is
yeah, go ahead.
No, I was just you please correct me. And what would that right be based on? Is it a right to medical privacy? Is it a right fundamental to me as an individual in America? What is that right now, according to law, built upon?
Yeah, I mean, probably the best way to put the right is that you have a right to an abortion before viability, but with some limits, right? So at the moment, no state can just say you can't have an abortion, period. But they can say you can have an abortion, but you have to, tell your mom and dad, you have to pay for it, you have to wait 48 hours, et cetera, et cetera. So that's kind of the boundaries. And what was your other question? I'm so sorry. I just spaced.
Oh no, that what was that based on?
Oh, sure,
no, I
yeah.
really appreciate that clarification. Is it because that as an American, I guess what I'm getting at is abortion law really about a woman's issue? Is it about we hear a woman's right to choose? Is it really about that, or is it about something about medical privacy, the individual versus the rights of the state, and overstepping and those two different pillars that it's constantly at tension in America? So what is it based on right now?
So the original Roe decision was definitely a medical privacy decision. Obviously, since then, Casey moved a little bit away from Roe. So Casey and Roe both said that the right to abortion basically is about autonomy in part, right? That's a big part of it. So the basic idea is that in the Constitution, in US law, we allow people as individuals to make certain key life decisions without government interference, right? So if you want to get married or not, the government doesn't come in and say you can't or you have to. If you want to have, procreate or not, right? The government can't come in and sterilize you. If you want to decide, how you want to care for your children, or who's going to have custody of your children, if you have you're a parent, you have rights. The government can't tell you, how to dictate your children's religious upbringing or medical decisions, that sort of thing. So in Roe and in Casey, the court said essentially abortion strikes us as the same kind of critical life decision that isn't the government's business. So they would, particularly because they had already said the same thing about the decision to want to become a parent and the decision to use birth control. So they said, in our view, abortion is the same kind of decision. Since then, and this was more visible in Casey than Roe, the women's piece of it came in, because when the court was explaining why it had chosen not to overrule Roe, it talked a lot about reliance. So it said essentially people rely on the availability of abortion if their contraception fails, or they have a wanted pregnancy and something goes wrong with their health, or maybe with the baby or the fetus's health. They rely on the existence of abortion, and that's made women in America more equal. Now that's contested, obviously, by people who don't support legal abortion, but that kind of made it sort of somewhere in between concerns about equality for women and concerns more about autonomy and decision making, right? That they're decisions that we think the government should butt out of. So that's sort of where the framework is. Now, people who are opposed to abortion will often argue, there's nothing in the text of the Constitution about abortion. And that when we often think about constitutional rights, we think about what the framers or the founders of the United States would have thought. And there's maybe reason to think they wouldn't have thought there was a right to abortion, because when the 14th Amendment, which is the relevant part of the Constitution, was written, a lot of states were starting to criminalize abortion earlier in pregnancy. That's a good argument. The tricky thing about it is that it maybe proves too much, as lawyers would say, because it seems in the 19th century that the framers of the 14th Amendment definitely didn't think contraception was a right either. And they probably didn't think that interracial couples could get married. And, essentially the question is, if the Supreme Court wants to go down that road, how could they separate out abortion from other things that would freak everybody out if the Supreme Court said there was no right to do. Like if the Supreme Court said, oh yeah, states could tell married couples they can't use birth control anymore, and that interracial couples can't get married, like there'd be nobody who would be like, oh yay, that's great. Everyone would be upset. So the question there would be more, if that's the road they're going to take, how do they kind of carve off abortion from these other rights that have been connected to it?
But you bring in such an important point that I think often is missing, though, from this conversation in the news, which is that, yes, abortion law is about abortion, but the ramifications of that law can actually impact other things
Oh, yeah.
that we wouldn't even imagine could be
Mhm.
impacted. And that's one of the big conversations that's come up with the current Texas law. And so
Mhm.
the Texas law, when we start, for me, maybe not for you, Professor Ziegler, at the beginning of the year, that's not something that I anticipated the Supreme Court we kind of knew what the Supreme Court by the summer obviously was going to take up, what cases they were going to look at in the year ahead. And the Texas law wasn't implemented yet. So, there was a question. So Texas
Mhm.
comes out with this new a law regarding abortion. It's very unique. It's very different. And the Supreme Court just heard the arguments about this. Can you give us a big overview about why the Texas law is so unique and what you see as potentially some of the ramifications of the ruling regarding this particular law?
Yeah, so in some ways, the Texas laws sound familiar to people who've been following this. It's a version of what's called a heartbeat bill. So it bans abortion when a doctor can detect a heartbeat or fetal cardiac activity. The reason I'm using those terms is there's a disagreement about whether there is a heart at that point, or whether the heart is, there isn't anything developed enough to call a heart. That's usually, they say 6 weeks, but it's worth clarifying that, if you're a woman and you're listening to this, it's not 6 weeks after you're pregnant, it's 6 weeks after your last period. So it's more like 2 weeks after you could know you were pregnant, right? Either because you missed a period, or you took a pregnancy test that says you're pregnant. And for people who have irregular periods, it may even be before that. So what's unusual about Texas's law is that most of the time when states pass abortion restrictions, they enforce them by either like stripping doctors of their medical licenses or subjecting them to criminal penalties, right? Like they have to go to prison or they have to pay a fine. Texas said, no, we're not going to do that. Instead, we're going to allow private citizens to bring lawsuits. And then the question was, okay, well, which private citizens? And Texas's answer was basically anybody, right? Doesn't have to be someone who knows someone who had the abortion, doesn't have to be someone in Texas, like quite literally anybody. And then that person can sue the doctor who's done the abortion or anyone who's aided or abetted that person. So aided or abetted is a criminal law term, but it basically means helped, right? So if you're
So can I
Sure,
pause
go
you
ahead.
for a moment there? So like I'm in a neighborhood, let's say somebody in the neighborhood, a neighbor finds out that they sought an abortion and their husband drove them
Mhm.
to an abortion provider. If that neighbor, or by the way, not even that neighbor, a Facebook friend from, let's use Massachusetts again, found that out, they could potentially, would it be sued even the husband that did the
Yep,
driving to get someone to get
totally.
his wife to the provider? And so anything kind of along the way there, just so we could get an
Yep.
idea of what it
Yeah.
could
And
look
then
like. Okay.
we know that if they could sue the husband, say for like at least $10,000, it could potentially be much more, right? So the suits that have been filed are asking for, upwards of $100,000. And to just get a sense of like how random this is, most of the people who file lawsuits at this point are disbarred attorneys from out of state who don't even know the people they're suing, right? They're just like, okay, 10 grand sounds good to me, sign me up. So it's that open-ended. Now, so why, one question you might have is like, well, why, that sounds pretty weird, why did Texas do that? And I think the biggest reason, there's a few reasons. The biggest reason is that Texas lawmakers wanted to pass, what they viewed as the most strong protections of life, or if you're, the most strong restrictions on abortion, and they didn't want to get sued. So there's a federal statute that says in certain kinds of causes of action, like constitutional cases, if you lose, you have to pay the other side's attorney's fees. And Texas had just lost a case in 2016 and had to pay the Center for Reproductive Rights, which is a pro-choice litigating group, over $2 million in attorney's fees. So the state was looking for a way to basically do what it wanted to do without exposing itself to having to pay millions of dollars again. So there's this rule essentially that limits in the US law when you can sue the state government in federal court. And the only exception that applies most of the time is you can try to block a law in federal court if you're suing the state official that's charged with enforcing the law. But Texas said, look, we found a loophole because no state official is charged with enforcing this law. The only people who can do anything are private citizens. So you can go to state court and play whack-a-mole where every time a doctor gets sued, they can, try to argue that that lawsuit isn't okay. But you can't ever get a federal court to say the law isn't constitutional once and for all because of this loophole. And that's what people have been fighting about ever since, basically, whether you can actually sue anyone in Texas for passing this law and get a federal court to tell you whether the law is constitutional, or if Texas has kind of found like armor that will protect that or prevent that from ever happening. And we're expecting the Supreme Court to say something about that, like quite literally anytime. Like it literally could, probably not today because it's a federal holiday, but any other day, we could expect the Supreme Court to tell us whether this law can be challenged or not.
And still, then it would still be a challenge in a federal court. So there'd still be more cases to it.
Oh yeah, it would just keep going, right? Most likely what it would mean would just be that Texas would then be sued in federal court, but that we would have to wait a while to hear if the law was actually unconstitutional, because Texas was sort of trying to block this thing from ever even getting into the courthouse door by saying, you just can't sue us here. Sorry, like, so if this law is unconstitutional or not, we may never find out because you can't ask the federal judge. So the Supreme Court is trying to figure out if that would work. And the reason that all sounds really technical, the reason that could be a big deal is if the Supreme Court says, actually, you know what, Texas, you guys are pretty ingenious. We can't hear this in federal court. Then we already know that lots of states are going to try to do the same thing for lots of rights, because there's no reason that this would only be applied to abortion. So just to take Massachusetts again, you have a right
to Massachusetts.
Yeah, I know. Well, I'm going to be teaching in Massachusetts. I love Massachusetts, so it's not personal. But say Massachusetts, you have a constitutional right now to, under the Second Amendment, to have a handgun in your home for self-defense. So Massachusetts could pass a law saying you can't have a handgun in your home for self-defense. And if you do, anyone anywhere can sue you for at least $10,000. And that, we know that that's probably unconstitutional under the law as it stands right now, but who cares? Because you can't do anything about it because you can't get into federal court. And you could do something similar for the right to vote, right? There's no logical stopping point. And so I think if the Supreme Court does wind up allowing the suit to go forward, it isn't necessarily going to be because the court is, a great friend of abortion rights or thinks Roe was rightly decided. It might be because they just realize that this is a way that states can kind of kick the federal courts out of the business of reviewing constitutional rights. Like any constitutional right doesn't have to be abortion, although in this case it happened to be.
That's what's so sort of fascinating about this law, is thinking about all the different things that someone could do in other states if the Texas law was applied there, where you could actually have your peers or strangers suing you for being supportive of a potential. It's kind of mind boggling. So you listen to the arguments. What did you think? I know it's very difficult. The Supreme Court in particular has proven to be unpredictable and kind of developing their own personalities with some new people, obviously, on the Supreme Court. What do you think they're going to do? If you saw a headline cross, they have a ruling on this, what does your gut tell you?
I think they're going to let so there are two lawsuits. It's worth saying, right? The Justice Department sued, and then the abortion providers from the state of Texas sued. I think they're going to let the abortion providers sue. The justices who are the sort of in the middle, right? The ones who we don't know how they're going to vote usually are Chief Justice John Roberts, Brett Kavanaugh, and Amy Coney Barrett. And Kavanaugh clearly had a lot of concerns about the Texas law. He was worried that this would sort of, allow states to nullify constitutional rights in a way that was worrisome. Barrett seemed to have some questions too. And Roberts had voted to even block the law from going into effect in September because he just thought that he called it unprecedented. So I think he was worried about what it would mean down the road. I think they're going to use that to try to avoid saying anything about the federal government's lawsuit, because the federal government's lawsuit is so complicated. Like, even if you're a lawyer, it's so complicated. So I think the court would be delighted to not have to tell anyone the answer to that. And they could do that by just, because the federal government's position basically was Texas did something unprecedented. No one can do anything about it. And we, as the federal government, have more power to sue than ordinary folks do. And we're only exercising that power here because we don't have an alternative. So if the Supreme Court can say, well, actually, other people can sue, so we don't even need to worry about you guys, because you were saying you only needed to do this because it was like a last resort. So if it's not a last resort, we'll just push that off to the side and not worry about it. That would be my guess. Again, that doesn't tell us a lot about abortion, because we have a major Mississippi abortion case that the court is going to hear December 1. And I think whatever the court does with that is going to be probably pretty unrelated to whatever happens in the Texas case.
Well, that's really important. So we'll put the Texas case kind of on ice right now. Know that we could see a ruling maybe by the time this interview even airs. And yet the Mississippi law is what was really anticipated going into this session, which is this is a law that's and I'll let you describe it, but it's a law that we can in some ways see in other states. And this was the one that there seems to be this high stakes game, and correct me, please, Professor Ziegler, about this could be the one that then fundamentally, while the Texas law could be applied in a lot of different ways, maybe, and it's more of a legal question, this Mississippi law seems more tied to actually abortion and abortion access in America. Can you talk to us a little bit about why did the Mississippi case get to the Supreme Court before others? And why does it seem like the stakes are that high with that particular legal challenge?
Yeah, I mean, so the Mississippi law is a big deal because, well, first of all, right, it's worth saying the Supreme Court never has to hear a case. So if you live in a state with an abortion law and you're like, oh, sooner or later, the Supreme Court's going to have to listen to this case. They don't, right? They don't have to listen to any case. They have complete discretion. Which sounds amazing, right? Could you imagine if your job was you could just say, you know what, I don't want to do any work. I'm going to just go golfing forever. Like, they could theoretically do that. And sometimes they don't take a lot of cases. So when they pick a case, it tells you that they wanted to hear this specific case for a reason. There are lots and lots of abortion cases that the Supreme Court could have decided without really doing anything major, but it chose this one. So why is this one potentially major? Mississippi passed a law in 2018 that bans abortion at 15 weeks. Obviously, one big thing is that that's a ban, right? It's not a waiting period. It's not a funding limit. It's an outright ban. And so you can't have any abortion, any reason after 15 weeks. And it's also a big deal because, as I mentioned earlier, this right to choose abortion applies until viability. And even though viability can vary, it's definitely after 15 weeks. There's no doctor who can, I mean, if you have a premature delivery at 15 weeks, it's not going to end well, right? So in order to say this Mississippi law is okay, the Supreme Court would either have to say there is no right to abortion, or that there is a right to abortion, but you can ban abortion sometimes before viability. Either of those things would be a big deal because it would be changing the rules in pretty fundamental ways. And if the Supreme Court gets rid of viability, there'd be a question of like, what does it replace it with? And there'd also be a question of, if the court is willing to rewrite Roe and Casey, are they then just going to overrule them a year or two down the road? I think and if you were guessing what the Supreme Court is most likely to do, I think you would guess that they would not overrule Roe and Casey entirely this summer, that they would probably more set the stage for a decision doing that, in a year or two.
And why would they do that? I mean, especially since the court is supposed to be, they're not political. They're supposed to be apolitical. They're supposed to just, why would you anticipate that sort of setup, or what would lead you to describe the court in that way?
Well, I think that there's a unique concern when it comes to abortion in the court, because ordinary Americans know what the court is doing on abortion. So the Supreme Court, and this is probably something that's good for people who are listening to this to think, the Supreme Court does a lot of important stuff that affects your life that you don't know about. And there's lots of data on this that a lot of people have absolutely no idea what the Supreme Court is doing a lot of the time or how it affects them. But when it comes to abortion, everybody knows, right? I mean, the media will talk about it, politicians will talk about it, neighbors will talk about it, like people will know and people will care. So the court has to worry more about how people will react, right? We know that the court's popularity right now is bad, right? I mean, they're at 40% approval. That's the lowest it's ever been. It's gone down from nearly 60% in the summer to 40% now. And that's because people often believe the court is partisan, right? They don't believe that the justices are above politics. So if the court thinks Roe was wrongly decided, it would be really stupid to just overrule it really quickly just because basically Amy Coney Barrett and Brett Kavanaugh joined the court. I mean, if the only thing that changed is that you have two justices who were placed there by Donald Trump who promised a court that would overrule Roe, and then that court immediately overrules Roe, that doesn't give the court any kind of separation from the politicians, which is not going to be good for the court's reputation. So if the court does think Roe is wrongly decided, we have reason to believe that might be true, then they would want to sort of take their time to explain to everybody why they think that, instead of just pulling the trigger right away, which will make them look like politicians, not like judges. And we already see that when that happens, their poll numbers take a hit. And if their poll numbers get low enough, that could actually get to be consequential, right? I mean, you see people in Congress occasionally floating the idea of like term limits for justices and that sort of thing. No one's taking that seriously now, but if the justices started doing things that people really didn't like, or that were struck some people as partisan, those kinds of conversations about the court might change.
So you're saying they may not be elected officials or politicians, but they're human.
Yeah, totally. And
they're just right. They're still thinking about, well, not only the legal challenges that they're looking on any number of topics, but also the resilience of the court that clearly they believe in, right?
And their own legacies too, right? I mean, these are people like, this is their life's work, and if they are viewed, forever as partisans, that would affect anyone personally, right? I mean, if you don't see yourself as a partisan and doing something a specific way would define you in the eyes of the public that way, that's going to cross your mind, right? I mean, I think.
So why do you think, I saw just on one of the things that you wrote recently, that Roe is on thin ice, and that you just said there that there's reason to believe that maybe they would be leaning towards to not overruling abortion overall, but creating some space for that to come eventually. What are the indicators that would suggest that?
I think the fact, again, that the court took this Mississippi case, if the court had wanted to kind of dodge big cases on abortion, it wouldn't have taken this case. And then I think, unfortunately, right, the court has been somewhat politicized. I don't think the justices are trying to be, but I think that politicians know that picking the right Supreme Court justices is a great way to get out the vote, right? I mean, we've seen Joe Biden and Donald Trump most recently promise what kind of Supreme Court justices they were going to give people. And so that has created a lot of pressure on, basically vetting judges by their judicial philosophy to try to predict how they would rule in certain cases. Now, the judges are not doing that because they're politicians, but they do have jurisprudential philosophies that tend to point you, in one direction or another, whether it's on guns or abortion or whatever. And so we don't really have reason to think that those vetting processes failed and produced judges who are not going to, rule in the way the politicians predicted. Obviously, that isn't necessarily true. That hasn't worked before, right? In the 90s, when the Supreme Court declined to overrule Roe entirely in Casey, there were 6 people on the court nominated by Republicans who identified as pro-life, and they didn't overrule Roe anyway. But obviously, if you had to guess, you would guess that the people screening judges would succeed rather than fail. And you would also, I think, be particularly inclined to think that, given that the justices took this case, because this just does not read like a court that's shy about, getting into it on abortion, because there were many, many ways they could have avoided doing that, and they didn't elect to take any of those options.
So what is at stake? What could potentially happen with this particular ruling on the Mississippi case?
I mean, I think what's the most likely outcome is that the court's going to say viability isn't the dividing line anymore. I don't think they're going to say what the new dividing line is. I think they'll probably say, okay, well, viability isn't it, so we're going to just kick this back to the lower courts because all the lower courts were proceeding on the wrong-headed assumption that viability was the line. So let's let them look at these laws with fresh eyes. No, they know viability isn't the line. What that's going to mean in practical terms is probably 2 things. Well, 3 things. One, I think we're still looking at the court probably overruling Roe in a couple of years. But between then and now, what that's going to mean is that states are going to, that are the more sort of red states, are going to pass more and more abortion restrictions, right? And they're going to be earlier and earlier in pregnancy. They're not going to have rape and incest exceptions, et cetera, et cetera. And we're going to expect to see too that more lower federal courts are going to uphold those laws, because they're going to start seeing, the messages being sent by the US Supreme Court, and they're going to say, okay, we don't need to block these laws until the US Supreme Court hears about it. We'll let them be in effect right now. So I think the kind of differences we already see between states are going to get sharper and sharper, kind of on the road to Roe being overturned altogether. And there'll probably be even more abortion regulations getting passed, because states are going to want to give the Supreme Court, the opportunity to take, the next step and the next step toward overruling Roe.
Do you ever see a scenario where abortion is completely illegal in certain states, that there's no access at all?
100%. Yeah. I mean, 1000%. I mean, we already know, right? I mean, Alabama has said that if it can, it wants to ban abortion. I think the only time I think Alabama does have a life of the mother exception. But I mean, that it's really hard to implement a life of the mother exception if people are, basically, if you're a doctor performing an abortion and you get that wrong, as Alabama's law would have it, you would go to prison for 99 years, right? So if you're a doctor and you're not 100% sure you're getting it right on that medical emergency front, or maybe it's not going to kill the person if you don't perform the abortion, maybe they're going to just become infertile, or maybe they're going to have to go to the hospital and be in the ICU for a month, but they're not going to die. You're not going to perform, so that's pretty close to just nothing, no abortion. And there's definitely no rape or incest exceptions. And we would expect to see a lot of states have essentially said, we plan on banning as many abortions as we can when Roe is gone. Like I said, I think among most states that are red states or pro-life states, they do have life of the mother exceptions, but there are procedural hurdles to that actually working. And also in practical terms, they're not that many scenarios. I mean, it does happen, but there are not that many scenarios where life would be threatened. The trickier thing would be more people who are, for example, people with ectopic pregnancies or incomplete miscarriages. There are patients, for example, there are women who have miscarriages where, the baby has died, but the heart is still beating, for example. If you're in a state that's going to punish an abortion by 99 years, you may not treat that person, right? You may look at that and say, I don't know if that's an abortion. I don't know if I want to get into that. But there's definitely, I mean, because states that are pro-life think that this is murder, right? So they're going to ban as much of it as they can.
So bringing the conversation then full circle, if existing law has to do with a right to medical privacy, but also that argument for equality for women that we talked about, then what is the basis? Where does that go? Does that just disappear as far as, what the law has been kind of like the pillars that the law has been standing on? Like what knocks down those pillars? Is it science? Is it medical advancements? Is it, if it's not a question of viability, then what is it that allows the court to say, actually, it's not about medical privacy. It's not about the individual. It's not actually about women's rights and equality. It's about this other thing, which means that states can decide to make it illegal.
I mean, most likely they're going to say it's about what the framers of the 14th Amendment meant. And they didn't think that it was a right for women, and they didn't think it was a right of medical privacy. And that's all that matters. Like, we're not, policymakers. We're just interpreting what they thought. Obviously, again, that's tricky because, the 14th Amendment was written in the late 19th century when a lot of people thought that it was okay to have, not allow Black children to go to school with white children, and a lot of other things that people on any side of the aisle would think were not okay anymore, right? So the question is always, how do you, if that's the route you're going to go, how do you explain how it's okay to follow the guidance of people who were writing in the 19th century on this thing, but not on this other thing, right? But I think that's the most likely thing the Supreme Court would do. And the trickier question, one of the other interesting questions is, people who are pro-life do not want this to be a states' rights issue. And frankly, people who are pro-choice don't want this to be a states' rights issue. So what pro-life people, the end goal, right, would be for the Supreme Court to say, a fetus or an unborn baby is a person, right? Is a rights holding person. And that therefore abortion is unconstitutional, full stop, right? It's unconstitutional in California, it's unconstitutional in Alabama. Like, you just can't have a legal abortion, period. I don't think the Supreme Court's going to go there yet, but I do think that we've already actually seen lawyers on the anti-abortion or pro-life side making that argument. And so we'd expect to see more of that. And it'll be interesting to see if the Supreme Court does overrule Roe, if anybody says anything about that, to kind of telegraph that the justices are or are not interested in arguments about personhood down the road.
Wow, there's so many different themes to pull on. And I find that a lot of the stories that we cover, whether it's about the pandemic or otherwise, really have to do with the individual versus the state versus the federal government, and the tension between all of those things, which is fundamental to America, which is how we're all sort of here. Okay, just a final question. And I've been so generous with your time. We could talk for hours, but I know you have a lot of things to do. So I look forward to talking to you more in the future about this. But if there's, as people are seeing headlines about abortion law, whether it's about Texas or whether it's about Mississippi, what can you leave us with? Is there a tip? I like to say to our guests, is there something smarter that you feel like people can look at a topic? What's a smarter tip for us about when we see these headlines, or something to remember about current law, existing law, future law, that you think is a really interesting point that sometimes maybe doesn't get the attention that it deserves?
I mean, I think probably the best tip is that while the Supreme Court is important here, I think we tend to focus too much on the Supreme Court. And one of the stories I like to tell about that is, the author of Roe v. Wade was a justice named Terry Blackman. And he had in his files a poll from 1972 saying that something like 70-something% of Americans thought that abortion should be a decision between a woman and her doctor. And Blackman thought, that's what we're going to say. Everybody is going to like it, and we're going to resolve this once and for all. And I think now a lot of people think the Supreme Court is going to let the states decide. Everybody will get to do what they want. This is going to go away. And if you follow this more closely, you begin to see that it's so much more complicated than anything the Supreme Court could resolve, right? Because it touches on people's most deeply held religious beliefs, their most deeply held beliefs about parenting, their most deeply held beliefs about career, their most deeply held beliefs about gender. I could go on and on. Their most deeply held beliefs about science, about the role of the federal government, about the role of state government, and the idea that the Supreme Court, any Supreme Court, could just swoop in and be like, all right, everybody, now we all agree, yay! That's just completely, to me as a historian, completely insane. I mean, and that would be true if the Supreme Court were super conservative, super liberal, nonpartisan. It doesn't really matter. There are just too many things going on here for one judicial decision to solve it, right? And so I think when you're following the news, it's always good to look at what's going on beyond the Supreme Court, because the best way to think about this, I think, is that the Supreme Court is in a conversation with the American people. It's not the only one talking. It's talking back and forth to us. And when we think about what's going to happen next, that's going to depend on a lot more people than just the 9 justices on the court.
That's really good advice. Really, really good advice. I love that idea of a continuing conversation. Well, Professor Ziegler, I hope we can continue this conversation too. I know you got a new book coming out in 2022. You're busy. You're a mom. You got all these rulings, and 1 million people are going to call you as soon as we get them.
Yeah, I'm glad we're doing this week, because every day I'm like, oh no, I hope they don't decide the Texas case, because then you can tell if you're me, because then your phone just blows up, right? You'll be like ding, ding, ding. You're like, uh-oh, they must have done something.
I was wondering, so do you get the news the same way as everybody? Is there a secret Supreme Court press release that experts really get, or
essentially because the media gets the secret Supreme Court press releases? And so there was actually the funniest story that way. When Anthony Kennedy retired, the justice who Brett Kavanaugh was going to replace, it was late in the summer, so everybody thought there were going to be no Supreme Court retirements. And so I was with my family on the beach. And, we thought we were good. We thought we were going to just have a vacation. And then all of a sudden my phone dings, and then it starts dinging. It was really blowing up, ding, 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 ding. And my husband's like, I bet Anthony Kennedy retired, right? And I'm like, yeah, that's got to be it. Because, so that's how I find out. I find out a few minutes after the reporters, when they start blowing up my phone.
So we're talking kind of mid-November. And so we'll see if we get through the next week, get to the Thanksgiving break, you might be safe. But like you said, the Texas law you could get a decision any moment. And then we expect Mississippi not until the summer. Would that be correct?
Right, yeah.
Not until
I expect Mississippi probably end of late June.
Late June. So we have to wait a little while. Well, Professor Ziegler, we really appreciate your expertise and I really appreciate the time. And thank you for providing us this foundation. I think this is going to be very helpful for so many news stories. And I hope to have you back to talk about it more.
Definitely. Yeah, I'd be happy to.
Thank you so much.
Quick, concise, nonpartisan, smarter news, a refuge from the storm. I'm Jenna. Thank you for choosing smarter.